Yeah, real water would suggest excluding 1.07.
Robbins.
We agree that it's better to just exclude it.
I don't think we want to get into that, Your Honor, but I would agree with Mr. Odou. I don't want that 1.07 if I get a vote.
We're fine to withdraw that one.
I mean, if you all agree, you agree.
Let's withdraw.
It's not my case, right?
It's fine. No, it says flat out, you are not to discuss or even consider whether or not the plaintiff was carrying insurance to cover medical bills, loss of earnings. You are not to discuss or even consider whether or not the defendants will carry insurance. But if they don't want to get into it at all, that's fine too.
I mean, it's your case, you know. I have thoughts. I will not express them.
Let's hear your thoughts, Your Honor.
No. It's your case. If you all agree, I'm fine with it.
Hannah proposed it. I mean, I don't.
No,
No, we're fine to get rid of it. I just said we're fine to get rid of 107,
I'm not an
1.07.
advocate, right? If everyone agrees. I think historically, that's how I've always thought about cases. For example, if you want to waive the 5-year rule, you do it. I just have to marsh you to this finality at some point. But that's not my case. So if everyone agrees, we'll move on to the next.
Page 9 is jury instruction 1.08, impartiality of the court.
Everyone agrees?
Real water agrees.
Agreed.
Yes, Your Honor.
Okay.
Page 10 is jury instruction 2.00, direct and circumstantial evidence.
Real water agrees.
Agrees.
Yes.
Got it?
Page 11 is jury instruction 2.01, jury to consider all the evidence.
Real water agrees.
Agrees.
Yes.
Page 12 is jury instruction 2.03, deposition evidence.
Real water agrees.
Agrees.
Page 13 is jury instruction 2.04, answers to interrogatories as evidence.
Real water agrees.
I'm trying to think if there's been interrogatories that have been put into evidence.
Fair enough.
Yeah,
Well,
interrogatory
we haven't officially done it, I suppose, but it will be.
to Milwaukee regarding Carl Salvaggio signed the actual
If
response.
it's in there, then I'm fine with 204.
All right. Page 14 is jury instruction 2.05, responses to requests for admission as evidence.
Real water agrees.
So if they come into evidence, I'm not sure that they have yet, so.
They have, we just have, we have to do the redactions to make sure that there's nothing.
Okay.
And Eric, before we get to 207, we proposed 206, which is stipulations of evidence. Counsel for parties have stipulated to any fact will regard that fact as being conclusively proved as to the party or parties making the stipulation.
Liability.
Liability and causation, those are binding on the jury.
Okay. Oh, that's a fact.
The facts that go into those are agreed upon, or waived, or whatever you want to call it.
I don't have a big objection.
So, I mean, do we agree?
Let's get it, Your Honor.
We agree, everyone, Mr. Robbins?
No objection, Your
No
Honor.
objection.
And for the record, that was
206, Your Honor.
2.6. Let me see here. So I don't have it in my set.
It's in the real water.
It's in also in Hannah's.
I'll have that, I'll call this my master set.
Page 9.
Is that in Mr. Odou's?
Yes, sir. Page 9 of the real water proposal.
Well, since everyone agrees, I think you have to give this because stipulation, I don't mean that everybody understands what that means. Right? Okay, so I got that, that's agreed upon, right?
Page 15 is jury instruction 2.07, credibility of witness.
Will Water agrees.
Agreed.
So next up would be,
Page 16, jury instruction 2.08, discrepancies in the witness's testimony.
Will Water agrees.
Agreed.
so we got the request for admissions, that was agreed upon. Credibility, that was agreed upon, right?
Yes.
So now we're at 16, that's discrepancies agreed, correct?
Yes.
Yes, Your Honor. We had also, after this one, had an additional proposal that wasn't in the plaintiff's stack, which was witnesses interviewed by an attorney. Although I can withdraw that, I don't think that applies any longer. We had
That was
an
two.
issue on that.
Two dollars, yeah.
NFW's out,
Right.
so
Okay, so we don't need to give that one?
we don't believe that that's necessary anymore.
So we go from discrepancies in a witness's testimony, which is page 16, to expert?
Yes.
Page
Yes, Your Honor.
Yes, and jury instruction 2.11, I think we agree on.
We agree.
Agreed.
The next one is not in plaintiff's stack, it's, I believe, in Hannah's stack. It's jury instruction 2.12, which is hypotheticals to experts. We didn't include it just because there haven't been any hypotheticals. If there is, we have no objection to it. If there's not, we don't see any reason to include it.
Okay.
So there may be hypotheticals asked of the expert witnesses that we call. That's why it's here. If I don't ask any hypotheticals, then we can withdraw it.
Fair enough.
Wait, let me follow that. And this is in Hanna set, right?
Yes. It's down at the bottom of the reference would be Nevada jury instruction 2.12.
2.12, I don't see that. 2.12. Okay. I'm gonna write conditional. Okay.
Page 18 is jury instruction 3.00, the burden of proof, preponderance of the evidence.
We agree?
It's not really applicable to real water. I guess we don't really have a dog in this fight.
We do, so we were trying to have it in.
Mr. Robbins? It has to be, it has to be.
Moved on from that one.
Okay, preponderance of the evidence, we have to give that.
Yes. I wish we didn't, but yes.
We have to.
Your Honor, the next two, in logical
I
order.
even think if the parties didn't want to put that in the instructions, I think it would be reverse where.
It's chaos, you know.
Right? I'd have to give it, I'd have to overrule everyone and give that. Okay, let's go on.
The next two are proposals from Real Water. It's standard instruction 3.01, number of witnesses.
We added that one as well, 3.01.
Okay.
And that would be, how does the plaintiff feel about that one? 3.01?
I mean, it's a stock instruction.
I guess that's not 3.01, it's 3.
All right, 4. Yeah, it's just the stock 3.01.
Number of witnesses,
Yes, Your Honor.
okay, I'm gonna give that. go to, let me make sure I pull it. Yeah, let me see. I don't want to mess it up. No, I get 3.01. Is it in there? So that's next.
2.01 is in or out?
It's in.
The next one that we had in order, Your Honor, maybe it makes sense to put it someplace else, but we had that defendants, AffinityLifestyles.com Inc., Real Water Inc., admitted liability and causation in this case. There's nothing to decide in regard to these defendants other than what are reasonable damages awarded to plaintiffs.
Said in Stockholm.
What about the punitive damages?
Reasonable damages, and I think if you put it with the, before the punitive damages question, that would be a logical place, but I think it's
There's nothing to decide. You're saying that.
they have to decide yes or no.
You should say there's other than what the reasonable damages and punitive damages needs to have. Those three words need to be added.
I think if you add and punitive damages, it makes it more confusing.
Well, it's wrong if you don't have that.
It's not wrong, they have to find.
There's nothing to decide. Nothing to decide except
Let me
damages.
see.
That's wrong.
What do I? This, oh yes. Right here? Okay.
It's on page 13 of the Real Water proposed instructions.
It says they've admitted liability and causation in this case. There's nothing to decide in regards to these defendants other than what are reasonable damages to work plaintiffs. But there is an additional thing to decide whether they're liable for punitive damages. So you can't say there's nothing except damages, because that's on jury, don't consider the punitive question.
We disagree.
Could say, there's nothing to decide in regard to these defendants other than what are reasonable damages to award the plaintiffs and Real Water's liability for punitive damages.
Why you put nothing in there? Why don't you say
All of
after causation of case, after that period, you said,
all of that's required.
yeah. I like the title to change. Liability as to real world defendants has been determined.
You know, we do have an admitted liability instruction, right?
We didn't find it.
10.01. I realize you highfalutin lawyers, you know,
Oh, no.
but I was trying rear-end motor vehicle accident cases, and I know exactly where it's at. It's at 10.01, and I do think you do have to put a full indication as to all damages they shall consider.
I have that in my group. However, I know there's a lot of stuff that would have to be changed about that one because there are three separate defendants here. So it's here, but I think we have to work out the language for 10.01 in order for it to be allowed.
I mean, we have to give an admitted damage instruction or admitted liability instruction as it relates to the law. That's a given because that's the current status of the case. And I guess it would be the defendant, Real Water, has admitted liability for plaintiff's personal injuries. And we haven't got the causation. Is it going to be substantial factor and or approximate cause?
Well, our position is it's substantial factor.
Right? Well, I knew that was going to come up. We have a case directly on point that deals with that issue that says if it's a products liability case, it's a substantial factor. That's right here in the blue book.
That's what the jury instruction says, Your Honor, yes, that's right.
And the reason I bring that up, I mean, you know, how many jury trials have we had go to trial in this department? I would rather say I don't know and I don't care, but it's been a lot, right? But we'll get to that later. Why can't we, because I agree, you have to put in the admitted liability instruction, specifically what damages, each individual category of damages the jury is to consider, even though liability is admitted. And so if you take a look at Nevada Pattern Jury Instruction 10.01, it would be, quote, the defendant, Will Water, has admitted liability for plaintiff's personal injury. And then we have to change approximately caused by to, I guess, that was a substantial factor in something like that. But we need to make this, we need to change this instruction.
Yeah.
You see what I mean? And then also, you have to give a definition of substantial factor. It's straight out of the case, I mean, out of the jury instruction. And then you go through and give the category of damages or to consider as a result of admitting liability.
Well, yes, I completely agree, Your Honor, and we have that in there in some form, and I don't know that it's anything that you said, there's any dispute amongst the parties, it's just wording it in a way.
I mean, I don't want to have to write it for you. That's not much, right? But it would take me 3 minutes to write this instruction,
We'll go back and work with plaintiffs on that.
right?
Get rid of the 10.01.
10.01, I think we'd also just want a sentence that says, Hanna Instruments has not admitted liability. I think that's fair, we have not.
Well, I don't think it would be in 10.01. You might have another separate jury instruction for your client and for Mr. Robbins' client.
Well,
Because remember this, when it said admitted liability, it would say the defendant, Real Water.
right,
It doesn't say all defendants. There'll
right.
be a separate instruction for the other defendants.
Well, that's on the, it's on the 1986 edition, so would you like us to create one and then for everyone to consider?
Well, I think you have to.
I'm not saying you don't, I just want to make sure that,
Yeah, no, but all I want to do is what's right, and I don't want to confuse the jury.
I agree.
That's really what it comes down to. Just want to do what's right. And just as important, what would sustain appellate review, right? And just as important, if whatever we come up with, if there's no agreement, I want whoever disagrees to make the record, so the Supreme Court can deal with it. So, for the record, as far as it relates to proposed jury instruction, I guess it would be 10.01, Nevada Pattern Jury Instruction. We have to tailor that to the specifics of this case, right? And so going back to, and this is where I get this from, and let me see here, approximate cause, where is that at? That's, what number?
It's actually the next one, on page 20 of plaintiff's, the element.
And that comes out of the pattern.
So 20 is the elements, and 21 is the definition of a legal cause, which is the social factor.
Is that, which instruction is it?
The elements are jury instruction 7.01.
Okay, that's what I'm looking for.
I'm sorry, 7.02. And the legal cause definition is from the negligence section. But it doesn't reference negligence. It's 4.04A in the 1986 edition. And Your Honor, if you look at page 35.
Where is is the approximate cause instruction? That is, I realize we're not gonna use that, but there is a, let me see here, 4.04. And I don't know if we've gotten there yet, but if you look at the legal cause definition versus approximate cause definition, I don't even know if that's in there, but it says, quote, "A legal cause of injury, damage, loss, or harm is a cause which is a substantial factor in bringing about the injury, damage, loss, or harm." Then if you look at the comments, and it says, "The author cautions the only Nevada case to discuss the substantial factor test is the one that was applied in Carlson versus Jack, which was, to my understanding, a strict liability case." So let's talk about that. Because I think we have to have either approximate cause and or legal cause instruction, so they understand what that means.
I thought we had it at, number 20, page 21, Your Honor.
Let me see, Mr. Parker, I might be jumping
Yeah,
ahead of the game.
4.04A, page 21 of the plaintiff's proposal.
Yeah, that's straight out of the 404A, so I guess I was just ahead of you.
Yep, is that?
Your Honor, we'd like to make a record on that,
Okay,
when you get to
okay, when we get to it.
21, yeah.
All right. So let's go back to, I guess this would be a 701. Let me make sure I get this all in line. So for the record, we're going to give Nevada pattern jury instruction 301. That was the preponderance of the evidence with the number of witnesses. That's the one we have agreement on. So now we're moving to page 19. Multiple legal theories.
Your Honor, we did have approximate cause instruction at 4.04. Are we saying that's out?
No, I haven't gotten there yet.
Well, 7 I thought was,
That's two instructions later, Scott.
No, I think that starts on, I didn't want to confuse the record. I think that's in, I'm just going through their list. That would be page 21. So it's two more to go.
thank you, Your Honor.
And that's where I think Mr. Robbins would like to make a record potentially. It depends on what I got.
We'd like to make a record with regard to the plaintiff's proposed jury instruction on page 19 as well.
Okay. And then this is instruction, multiple legal theories.
Yes, Your Honor.
All right. You can make a record, sir.
Plaintiff's proposed jury instructions states as follows. Plaintiffs seek to establish liability against defendants Milwaukee and Hanna on one or both of two different legal bases. 1, defective product because of failure to warrant. 2, breach of the implied warranty of fitness for a particular purpose. I will now instruct you on the law related to these claims. And that's the ones that come after that. Looking at, Ms. Torrey, I'm sorry I don't have the specific docket number, but the plaintiffs filed a second amended complaint on March 9th, 2023. There are 7 causes of action in the complaint. Just the court is aware, in the first complaint filed by the plaintiffs, Hanna and Milwaukee were not named. So later in amended complaints, and the last one being the second amended complaint, the plaintiffs were named. There are 2 causes of action related to.
You mean the defendants were named?
The defendants, Hanna and Milwaukee, were named.
Right.
Yes.
The reason I said that, you said plaintiffs were named, but go ahead.
You're right, I misspoke.
Yeah.
In that complaint, there are 2 causes of action because the plaintiffs have gone through and identified in each one of their causes of action as to whom, which each one of them each one of the cause of actions relates to. The first cause of action against states as follows, I'm not going to read the whole thing. First cause of action, strict liability, failure to warn against the real water defendants and defendant UNF, who's, we know, UNF is not here. After that, they go on to the next one. Second cause, breach of implied warranty and merchantability. Now, that particular cause of action could never be brought against Real Water since we never sold our product to the plaintiff. Number 3, negligence per se. Negligence was not brought against Hanna or Milwaukee. Number 4, negligence against the Real Water defendants and defendant UNF. Again, does not identify Hanna or Milwaukee. Number 5, strict liability, unreasonably dangerous against the Real Water defendants and defendant UNF. Number 6, this is where there's one against the Hanna and Milwaukee. It says strict liability, dash, failure to warn. We agree that this cause of action was something that has been brought against Hanna Instruments, and I'll let Mr. Robbins discuss whether that's against Milwaukee as well. The 7th cause of action states as follows: strict liability. It says unreasonably dangerous against defendants Hanna Instruments and Milwaukee Instruments. Paragraph 168 of that particular complaint, the second amended complaint, states as follows: the MW500 ORP meter is an unreasonably dangerous product because consumers would not expect, 1, that the MW500 ORP meter would not give accurate readings when used for negative ORP meters, or 2, the MW500 would not give accurate readings when used for negative ORP measurements unless rigorously cleaned every 30 days. That's what it says. Then it gives the approximate result and toxins that were in the bottled water products, and that the plaintiffs have suffered substantial adverse health consequences, including severe liver damage. Nowhere's in there is there notice anywhere in that 7th cause of action to put my client on notice that it would have to defend a cause of action for breach of the implied warranty of fitness for a particular purpose. Part of that analysis is that you have to have notice. And although I appreciate Mr. Kemp's discussion with regard to notice pleading, I don't believe that this provides me notice that I'm going to have to defend a breach of implied warranty of fitness for a particular purpose, cause of action. And the 2 underlying things that allegedly Hanna and Milwaukee did is that it was an unreasonably dangerous product because consumers would not expect. And of course, part of our defense in here is whether or not Real Water is a consumer. But be that as it may, number 1 was that the meter would not give accurate readings when used for negative ORP readings, or that it needed to be vigorously cleaned every 30 days. Assuming that number 1 is still in play, because I don't think the vigorously cleaned one is still in play in this particular case based on the evidence that we've been able to collect so far, it does not give my client any notice that this is something that we have to deal with as far as a breach of implied warranty. This also goes now into the issue of whether or not there's horizontal or vertical privity with the actual plaintiffs. This product, meaning the MW500 ORP meter, was sold to Real Water. It was not sold to any of the plaintiffs. I don't think that fact is in dispute. So for a breach of implied warranty of fitness for a particular purpose or other, there has to be some sort of privity between the plaintiffs and the defendants. There is not here. In fact, the measurements taken of the samples done or read by personnel at Real Water is that whatever was measured was never a part of the product that was actually consumed by the plaintiffs. Likewise, this one is about accurate readings, and I don't think it tells me anything to say that there's an implied warranty of fitness for a particular purpose cause of action that my client needs to defend in this lawsuit. There's no privity, there's no consumption, the meter doesn't come in contact with the plaintiffs. Breach of implied warranty is a warranty claim. We made no warranties to the plaintiffs. So the warranty would go only as to real water. So it would fail in that regard. We made no warranties of any type with regard to the cleaning. So I fail to see where this particular cause of action provides for me any words about warranty. And I don't believe it would be accurate or something that would survive a motion for summary judgment. If it had been brought in these words and I had known that this is what the intent was, then we would have filed a motion for summary judgment specific with regard to that. Instead, we opposed their motion, that they tried to get this thing, and the court said, and limited the granting of that motion to no more, no less, you get to say these words and that's it. You did not create a third cause of action. At the end of this second amended complaint, there is no eighth cause of action, none. Thus, when you said, in this case, during the motions hearing, you said the following.
Page 144?
Yes, the court. All right, and gentlemen, this is what I'm going to do. I just want to make sure I get this correct. Okay. What I'm going to do as far as the motion is concerned is it's going to be limited to the request that specifically sets forth on page 11 of the conclusion. And that would be MW fiber was being used to take negative warp readings when making alkaline water, period. Nothing more, nothing less. Mr. Robbins, and that's expressly as you stated, Your Honor, right? The court, yes. Mr. Robbins, okay, the court. Well, I did that on purpose. So break, or where do we go from, what time is it, and then we do a break or something like that. I don't know how much more plain the court could have been as to exactly what was going to be allowed and what was not. That this was not going to be a new cause of action, and I don't believe in the second amendment complaint that I have noticed that that is something I have to deal with as far as a warranty claim. And I put down all the other causes of action because the plaintiffs did bring a breach of warranty claim against Real Water for breach of implied warranty of merchantability. So they know what this particular cause of action would look like. In fact, it is actually a cause of action I am having to defend in other Real Water / plaintiff cases that they have. It's just not here. It wasn't brought. I don't have the experts that I could bring to defend that specific cause of action. I have 2 experts to deal with warnings and an expert to deal with unreasonably dangerous meter. I don't have experts to deal with this cause of action of a breach of an implied warranty for merchantability, for fitness for a particular purpose.
I'm following you.
Okay. And therefore, I've made my record, I think, as to why this would be unfair to have it in a jury instruction down to say, I'm going to give you the law on particular purpose when we have not had it here in this case. And it is not in the complaint as of March of this year. Then we have our expert reports, which are due at the end of March. Actually, 15 days later. We do our expert reports. We do our rebuttal reports in April. We conclude discovery in the beginning of June 9th. And then we start motions in July. And when the motion is filed, we filed our opposition to it. And the court was clear on the record as to what it viewed with regard to this. And so that's my record. Thank you.
You're welcome, sir.
Just briefly in response, we argued this notice pleading issue when we did the motion for summary judgment. We talked about the listing case, we talked about Schwartz versus Adams, we talked about in the new Court of Appeals case, we talked about 2 other Nevada decisions, all of which said the rule that Nevada is a notice pleading state. Doesn't matter what the title of the causes of action are, you've given fair notice of the claim. And how can you say with a straight face that a claim that says the meter is unreasonably dangerous because it doesn't give accurate negative warp readings does not encompass a claim that the meter is not fit because it doesn't take accurate negative warp readings? The only difference is unreasonably dangerous and fit. That's the only difference. So to suggest that the complaint is not adequately pled, this theory, that would violate, all these Nevada decades. The Liston case was 1966. So decades of Nevada case law, and that would revert Nevada back to a formalistic pleading state, which we're not. We've never been. And with regards to the privity issue, I raised the privity issue in a footnote of the motion. They didn't respond to it. They didn't say one single word in their opposition about privity. Now they get up and they say privity, privity, privity. Well, as I respond in that footnote, there's cases, Professor Prosser, the title of his article was The Citadel of Privity Has Been Smashed, or something to that effect. Privity is not a defense at this point. Whether he calls it vertical privity, horizontal privity, it's not a defense. So I raised the point in my briefings, they didn't say a word about it. And now they come up at the last minute and they haven't even talked about the cases that I addressed in there. There was a case, I think, from Judge Odou, there was a couple other cases, but privity is not a defense. And there was, in particular, there was a Court of Appeals case that involved a dental office, and the dentist was manufacturing a device. And this whole privity issue, it was rejected by the Court of Appeals, and that was a decision that was 2 years ago. So finally, he says, when you granted the motion for summary judgment that one of the particular purposes was to take negative readings of alkaline water, you didn't allow the third cause of action. Well, Your Honor, it would be completely nonsensical to say, to rule that one of the particular purposes was this, if that was not a claim for relief that was going to be heard in this case. That was inherent in granting the motion for summary judgment, that decision on notice pleading, which again, that took the lion's share of the argument when we argued the motion. So to suggest that at this last minute they can come out, and in this motion, there's no surprise here. The motion for summary judgment was filed 4 months ago, number 6. I raised the issue, okay? I didn't sit back and wait to the last minute and say, we want to file a breach of implied warranty claim. I raised this on June 22nd, okay? So there's no surprise here. Claim, I'm surprised. June 22nd, we filed this motion. So for that reason, Your Honor, the claim's proper. It would be improper to hold that Nevada is not a notice pleading state after all these decades of case law. And I also point out, I dropped the unreasonably dangerous claim. I've taken that out. So there's 2 claims for relief. There's failure to warn and this merchantability. There's not an unreasonably dangerous claim.
Mr. Robbins.
Yeah, I just want to add 2 things. I don't want to go back and relitigate this, and it's probably in the transcript I gave you. But our position at that hearing was that, yes, it's a notice pleading state, but they actually amended, in all their other cases, they actually amended their pleading to state that. This is the only one they didn't. So they actually, and I argued to this, maybe not effectively and maybe not in a winning way, but that to me said they were not going to bring this cause of action. And then they brought it when we were doing the limiting motions. The other issue is, I'm going to let Ms. Lowell address it. We did raise, and I think Hanna did too, the privity issue in our oppositions to the motion. So I don't understand that comment either. And if you want to hear from Ms. Lowell on it, she's itching to tell you her issues with that.
I just want to reiterate also, I think, to move forward, we just need a decision. We need to know if this is in the case or out of the case. We need to know what language in the complaint gave us notice and privity of a claim for breach of warranty. And privity, the case law calls it privity. We're talking about a statute. They're asserting a statutory claim. They say it's already in there. It's NRS 104-2315 for implied warranty for breach of fitness for a particular purpose.
104 what again?
2315. Now that's the claim. The claim is under 2315. That is a UCC claim from Chapter 104 of the Nevada statutes under the UCC. It is not a tort claim. It's a contractual claim. I understand that there are cases that I can talk about that talk about vertical privity up and down the line of distribution. That means I as the buyer, I can go after United Natural Foods who sold the product to me. But I can also go through them up the chain of distribution to Real Water that manufactured the product, and under the privity statute, which I'm about to tell you about, is I think they're redefining everyone in the chain of distribution as a seller. But I don't know how you can say that this NRS 104-2318, which is right next to them, which says third-party beneficiaries of warranties, express or implied, and then it says a seller's warranty, either express or implied, extends to any natural person who is in the family or household of the seller's buyer, or who is a guest in his or her home, if it is reasonable to expect that such person may use, consume, or be affected by the goods. So plaintiffs need to show, in order to bring a claim for breach of warranty, they have to say horizontal privity is when they're in that group of people. They're next to the buyer, they're family of the buyer, they're guests of the buyer. Those are the only third-party beneficiaries. And I don't know how we can, I mean, there's no case law that says the Nevada Supreme Court is completely abrogating the statute and making it so it doesn't apply. And if we want to get into the cases that talk about it, I can talk about it. Chiabani is not a breach of implied warranty case, or at least, I wasn't the person who brought it and argued it, but in the opinion by the Supreme Court, they talk about strict liability, and they talk about the ability of a bystander who is injured to bring a claim under strict liability. They don't talk about privity. The other case, the Cronin, the dental case, that is also about strict liability. It is not about a breach of implied warranty. And even if it was, the guy who bought the dental implant, he had horizontal privity. So I mean, perhaps there is another case that I've been researching it, but I don't know where the Nevada Supreme Court says, we just don't think NRS 104-2318 applies anymore at all. And I think if Your Honor allows this jury instruction and allows this claim, it would be helpful to make a record as to the basis for ignoring that statute.
Chiabani was my case, okay? And they argued in that case, just like counsel here is arguing, that you can't extend it to a bystander. If you remember, Dr. Chiabani was riding his bicycle next to a bus. We sued the bus manufacturer, arguing that the bus, there was a failure to warn, okay? So they came in, Mr. Polsenberg, and said, oh, bystander, there's no vertical privity. The exact same thing they're saying. That was the argument in Chiabani, and Chiabani rejected it, just like the dental implant case rejected it. So the vertical privity argument should be gone from those cases. Now, with regards to their other arguments, I didn't hear any more about the amendment, so I guess they dropped that. But this statute, we are the intended user of the product. The product was made for the consumers like the plaintiffs in this case. It wasn't made to put on lawns in some sort of sprinkling system or to fill up bathtubs. It was made for us. We're the consumers. So to suggest that we don't have a claim, it's just not appropriate, Your Honor. But in any event, that's why we have split the claims out like we're supposed to under Allstate versus Miller. There's a claim for failure to warn, and then the second claim, a different yes and no box for the implied warranty. If they want to argue to the Supreme Court that Chiabani should be rejected and that the dental implant case should be rejected because now we're just going to combine these issues to bystanders, I don't have any problem with that, Your Honor. But it should be on the verdict form because it's a claim that they had notice of, and the elements are supported by the facts in this case.
All right. And I have one last question. Who were those two sites again?
Kiabani, we find Kiabani. They're in our summary judgment motion, Your Honor. The Kiabani and the,
That's in docket 307. I can pull it.
yeah, it's either in the motion or reply. I think it's in the motion actually, because
I have the
I-
site if you
yeah.
want.
I have Giovanni. Giovanni's
130.
130. Sorry, Elizabeth.
137 Nevada 416. And the Cronin case,
416.
416.
the Cronin case is 523. It's unpublished. It says 526, sorry, P third, 1111.
1,111. Who issued that decision?
it's Court of Appeals decision, Your Honor.
What are we needing a power person? I can give you a copy of it if you'd like.
Court of Appeals, Your Honor.
Yeah, I want to say it was Justice Bueller, but I'm not.
I understand what the issues are. Let's move on to the next one, because I need to go back and take a look. I'll do that. So, for the record, I just want to make sure we get back to where we were at. As far as jury instruction, you've added jury instruction, proposed claims instruction 7.01. This court shall consider. Okay? We'll go back and look at the cases and take a quick look at the summary judgment motion. And maybe I'll pull cases. Read the 137 Nevada 416, that case. And I'll take a look and see what Judge Bullis, her decision and the reason for it. I realize it's not persuasive. I'll read it because I used to work with her.
We all.
I think it was less than a year ago that decision came out.
Yeah, I'll look at it just to see what,
It's this year.
we worked together for about 5 or 6 years. All right, so where do we go from there? Page 20?
So page 20 is a modified version of jury instruction 7.02. We streamlined it to ask, there's no dispute handing Milwaukee distributors of the work meter. So we limited it to the two elements that the MW 500 was defective and that the defect was a legal cause of the damages or injuries to each plant.
Make a record on this one as well, Your Honor.
Okay, go ahead.
The last, proposed jury instruction from plaintiff 7.01 has to deal with, at least what they asked for, is a breach of the implied warranty of fitness for a particular purpose. That's just a warranty claim under the UCC and actually comes out of the negligence area of law. In this particular one in 20, we've now changed this to in order to establish a claim of strict liability for the defective product. The problem is, I think they're
Scott, I don't mean to interrupt you, but I think you're misunderstanding the intent. So the first 701 says is just the introductory stock to our causes of action, to our claims or legal theories. 1, defective product, failure to warn, and 2, breach of the implied warranty of fitness for a particular purpose. So then these elements are just for the defective product, failure to warn claim, and then we get to the breach of implied warranty for fitness of a particular purpose. So this isn't meaning to instruct on what the law is on the second claim. This is just the first claim.
All right, if that's true, then I would suggest that we have it modified to say this is with regard to the failure to warn claim. Right now, I don't know that. I can't see that. In other words, it says, in order to establish a claim of strict liability for failure to warn, as opposed to for a defective product, then I think would be confusing to the jury to use that particular language. Strict liability for a failure to warn about the MW500, I think is more appropriate than saying for a defective product. I'm not saying that it isn't part of that, but then we have a warnings, and the plaintiffs have put those same one in at 7.05, but, so, again, moving back, if you're going to modify this, that's fine, but we need to make sure that it's somehow worked into and understood that this particular element one has to do with failure to warn. And I think it's confusing, it certainly was to me, that somehow this is about failure to warn, because it doesn't say this is strict liability, which is what 701 does say, defective product because of failure to warn. This one says, in order to establish a claim for strict liability for a defective product. And it should say, instead of for a defective product, it should say for failure to warn. And finally, in this one, part 4 of this is that the product was used in a manner which was reasonably foreseeable by the defendant. Was it reasonably foreseeable? That particular part of 7.02 was left out by the plaintiffs, which was a part of the stock, part of.
There's no issue on that, because one of the intended purposes is to take negative ore readings, so of alkaline water. So there's no evidence that it wasn't used for any purpose other than what was intended. So why ask the jury that?
We believe that the stock part of that is important for the foreseeability of what the use of the meter was for. In particular, when it comes to hydrazine. We've had to kind of make that as part of our defense in this case, and that is that we don't detect hydrazine.
There was a motion in limine precluding that defense, that argument. Plaintiff's
Actually,
motion
it
in limine
was
number
granted by
14.
the court.
It was granted. You cannot argue that the fact that the meter doesn't detect hydrazine is a defense.
We just have a disagreement on that.
That's what the court ordered. It's a court order. That's why we filed the motion in limine.
Our motion in limine number 6 was granted by the court with regard to that.
Yes, to preclude reference and argument that it detects hydrazine. We're not arguing that. That's not the theory. We're not saying it's defective because it didn't detect hydrazine.
Well, the state of record is that it's
But
not
I
true.
mean, if that was their theory, that this was designed to detect hydrazine, then there would have been potentially litigation on that specific issue. I mean, we do understand what the ORT meter was designed for, right? And the record's pretty clear in that respect, but it wasn't designed to detect hydrazine, and they have never presented evidence to support that it was a hydrazine meter. No, it's an ORT meter. So anyway, let's circle back to the jury instruction number 7.02.
They've also said that this is just a legal cause. We suggest that.
We're getting to that in the next one.
Yeah.
But in order to establish a claim for strict liability for a defective product
Yeah.
based upon failure to warn, is that what you're
Yeah.
saying?
That is the cause of action.
I think I'm fine with that. If we say for a defective product based on failure to warn, and the elements can be that the MW500 was defective because of inadequate warnings, and that the inadequate warning was a legal cause of the damages or injuries to each plaintiff.
And I think it should be approximate cause of the damages.
Setting aside that dispute, is that language okay?
Any other dispute, because you're not waiving the other two, I get you.
Or not.
I'm following you.
Thank you.
Why don't we read it one more time?
Because I mean, I do think that, it does say for a defective product, but we have to make sure, you're instructing the jury, what type of defect are we talking about? And I do understand that, lawyers get it when we talk about manufacturing defect or design defect and or failure to warn. And so I think we have to make sure that they understand what the legal theories are, because that's what the expert testified, right? That's what the defense expert will testify to, that the
Yes.
expert warning is adequate. And we get it. For us, we would need the additional language. For a jury, I think you do need that.
And I understand, Your Honor, and just to be clear, there's multiple instructions related to this, and we go on to define what a warning defect is, and what unreasonably dangerous is, and we have some specials on warning.
No, I get that, but I just think from a consistency perspective, because when you say for a defective product, it should be something there, how is it defective, so they don't lose sight during the.
No, I get it. I struggled with this one too, because I do think we need the elements in there, but it wasn't specific to failure to warn, so let me read it again and see if we can have an agreement, at least on the language, setting aside the other issues.
And then we'll address the other issues, so I make sure I know what I need to look at. But go ahead.
In order to establish a claim of strict liability for a defective product based on failure to warn.
Wait, hold it there. Okay.
The plaintiffs must prove the following elements by a preponderance of the evidence. 1, that the MW500 was defective because of inadequate warnings.
I think that makes it a lot clearer.
Yeah.
And 2, that the inadequate warning was a legal cause of the damages or injuries to each plaintiff.
I'm fine with that language. Of course, we don't agree with regard to legal, and we would like the word proximate, but that's going to be something the court can decide which way it will go.
Wait, I'll get there. And what was the next, because of inadequate warnings? Where does that go again?
Number 2, that the inadequate warning was a legal cause of the damages or injuries to each plaintiff.
So we take out defect?
Yeah, and replace defect with inadequate warning.
Do we agree with that language? And I understand you have objections to the rest of the instruction, but I'm just trying to peel away what can be agreed upon. Mr. Rasmussen?
I'm so sorry. I was just writing it down myself to make sure I've got the notes.
Yeah, exactly. So sentence 2 would be that the inadequate warning was, and I understand there's an objection to legal cause, but that the inadequate warning was a legal cause of the damages or injuries to each plaintiff.
I'm fine with that as well. I believe Eric said with regard to number 1, I want to make sure that my language in my notes is fine. The MW500 was defective based on a failure to warn. Is that what we added?
I said defective because of inadequate warning.
Because of inadequate warnings. That's what I.
Okay.
Which I think is appropriate.
I'm good with that as well, Your Honor. I think I've got it down.
Okay.
Just,
Yes, sir.
no, and I think this is clear, but we're gonna address this right now, I think, but we would object to the legal cause.
Okay. And not yet. I just want to make sure.
I just wanna make sure I'm not agreeing to
No,
that.
we're going to, that'll be, that objection's noted, and that comes up in the next legal cause
Next one, yeah.
definition. But I want to make sure I'm clear, because there's additional proposed language that was proposed for this instruction. And I want to make sure, Mr. Rasmussen, I understand what that language was.
Thank you, Your Honor.
And I guess this focusing on part 4 from the proposed elements for Nevada pattern jury instruction 7.02, is that it?
Yes.
That the prize, okay.
I'm going to go back and find my 4.02.
And that would be to add paragraph 4 from Nevada pattern jury instruction.
We have-
7.02.
In our packet that you have in front of you, we have Nevada Jury Instruction 4.04 from the 1986 edition. There's two competing ones that are there, we believe.
Yeah, but I'm not there yet.
I know that, just want to make sure you knew that we had that.
It's coming up next.
Okay,
But I want to make sure I understand that you're saying that the additional objection would be paragraph 4 from the Nevada pattern jury instruction 7.02, that the product was used in a manner which was reasonably foreseeable by the defendant should be part of it. I understand what Mr. Kemp's position is. I do. But I just want to make sure, because I'm going to go through these again, but I want to make sure my notes are appropriate. So when I issue a decision, I can do it.
thank you.
Okay, we're going to move on. Next, I guess, would be page 21, is that correct?
Yes.
Okay, let's talk about this one. Legal cause versus proximate cause.
Who would you like to start?
Whoever wants to take the floor first. I guess we'll save time. You can take the floor first because they proposed legal cause and your objection is proximate cause should be utilized.
So we proposed 4.04, but it still has to do with, these are of course causes of action with regard to negligence. I understand that, but since strict liability is part of the negligence area, the question is whether or not it should be a proximate cause of injury or a substantial factor. As the evidence is already shown, the substantial factor part of this would be that somehow the measures of this thing is what is bringing about the injury. Remember, it's a measurement. We didn't add hydrogen. I think that's absolutely clear. We didn't hire the real water personnel. We did a measurement. We didn't test the water. We didn't do anything to the water other than measure it at a particular time. The reason for that will come in later as the defense puts on its case. The question is which one of these is appropriate. The 4.04 and the supporting case law that it cites to, all of which is there in the comment section, and we can go through many different cases. The Van Cleve decision from 1981, the Taylor decision versus Silva in 1980. These are all older cases that all looked at these things and said this is what it is. But the reading is very important, I think, because it's a proximate cause of injury, damage or loss or harm is a cause which in natural continuous sequence produces the injury. Now, in this case, the hydrogen was introduced before the measurement was taken. We have that now into evidence through Dr. Najim already. So it's not the continuous, this is what would happen if you put hydrogen in this already. So we want that particular evidence because it's the natural cause, the natural continuous sequence produces the injury. I don't think so, but that's better than a legal cause of harm is a cause which is a substantial factor in bringing about the injury. It's not a substantial factor because it comes after the poison is already in the water. I know I use the word poison for hydrogen, I know it's chemical, but so we shouldn't be there because we're not a factor at all in bringing about the hydrogen, which their experts have testified. Both Dr. Hutton and Dr. Kosnet both testified the reason that these people were injured is because of the hydrogen, not the measuring of whether or not the water can donate or accept hydrogen atoms, which is all that an ORP meter does. It's an oxidation reduction potential. And so to say that it's the legal cause, I think, is just not the appropriate one for the elements that are there. Thank you.
Yeah, I just want to make a record, Your Honor. So we proposed 4.042 for the but-for proximate cause instruction. And the reason
4.04A, you mean?
4.04, no way.
No way, just 4.04.
Oh, okay. I think when you threw me off, you said 4.042.
We're TO, not.
I understand.
I lost a spelling bee once when we were in seventh grade, and I just brought it back because I didn't enunciate it properly. And the reason being is, and I'll just give a couple of citations here. Under Johnson v., I don't know how you say it, Ectodar, 112 Nevada 428, it points out that the but-for instruction should be abandoned in favor of the substantial factor instruction in cases in which an injury may have had two causes, either of which operating alone would have been sufficient to cause the injury. And the problem I struggle with, Your Honor, is if our meter, let's say, let's assume that it was off a little bit, and they, this is a bottled water company, they should have been putting, more bottled water products in, but unbeknownst to them, they were introducing hydrazine into their manufacturing process. So, and I think Dr. Najim answered the question for one of the jurors, is this something that we have to worry about in other bottled water companies? And he said, no, this is unique to this company. So if our meter is off a little bit or is off a lot, you shouldn't have hydrazine introduced into the system. So I don't think in that respect that the substantial factor is the appropriate instruction in this case. And then I would also add that under Wyeth, which is Wyeth v. Rowett, 126 Nevada 446, again, they went on to say that a substantial factor causation instruction is appropriate when an injury may have had two causes, either of which operating alone would have been sufficient to cause the injury. And I don't know how you get to that conclusion. And that for that reason, Your Honor, we asked at 4.04, the but-for instruction is more appropriate in this case, given the facts that have come out.
Okay. I mean, I have some thoughts. I'll hear from Mr. Pepperman, then I'll tell you what my thoughts are.
Well, Mr. Robbins neglects to mention the actual applicable holding from the Wyatt v. Rowett case, which is for but-for causation, you have to have two independent theories, two different theories that are competing against each other where it can only be one of them. That's what the but-for causation is for. There's no two independent theories here that only one of them can be the cause of the injury. It's like a cancer diagnosis, like in Wyatt v. Rowett, that was the drug that caused the cancer. No, it wasn't. It was smoking or some other thing that had nothing to do with the drug. But when two separate factors are operating together concurrently to bring about the injury, that's a legal cause substantial factor. It's I get into a car accident because the brakes fail and I hit the wall and the airbag doesn't go off. You have two separate claims. They're both substantial factors in bringing about the injuries. So that's what it is here. It doesn't matter what the contaminant is. Real Water was using this ORP meter to determine how much of the concentrate it was adding to the water. This meter was defective because it never warned that it would take hours to days to get an accurate or effective negative reading. The evidence is that these low readings were causing him to add more concentrate, which was containing the hydrazine. Dr. Kosnet testified that it's not just the introduction of hydrazine, it's the dose, the amount matters, brings about the injury. And that's what you have here. You have the Real Water's putting in the hydrazine, the meter's causing more of it to get in there, adding to the injury. So they're concurrent causes and they're both substantial factors, or at least that's how the jury should be instructed and be allowed to determine whether they're both substantial factors.
Okay. Here's my question, and I don't think any of you addressed it. I was looking at it through a slightly different lens. I mean, I do understand from a historical perspective the use of the approximate cost. Typically, you see those in negligence cases. What if it's a strict products liability case, right? And the reason why I asked that question, and it's been a long time, I will admit I haven't gone back and read Carlson v. Jack and also Thomas versus Rexall Drug and Chemical Company. And these are some of the California cases that Nevada, well, I guess one's not a Nevada California case, the other one is. But it seems to me that potentially legal cause or but-for causation would be utilized in a strict products liability case. If it's a negligence-based case or a breach of warranty, it would be approximate cause. Am I wrong in that analysis? I'm fine.
I think you're on,
Yeah. And tell me why.
because breach of implied warranty is in the negligence area, and therefore proximate cause but for would be part of that.
I just said that.
That's why I'm saying I agree with you on that.
Yeah, but what about but you said I was wrong.
No, I didn't.
Oh, I'm sorry. Yeah. Okay, but what about?
Don't watch my head, just watch my mouth, what I'm saying,
Okay.
it comes out of that.
But what about the products liability issue?
Right, so both of these ones are not, don't fit well in the strict product liability area, and there's no jury instruction that we found in the pattern jury instructions from 1986 that goes to either of these, because it's negligence as opposed to strict product liability. But if you're gonna have to choose between two of them to give it, I think it's proximate cause. Did we proximately cause this when it was done before? And I said this when I started out, I says, this is negligence versus strict product liability. Now we're trying to get an introduction of the implied warranty for a particular, breach of implied warranty for a particular purpose. It can't be legal cause, it should be proximate cause, because that's certainly, as that particular cause of action would be done under some sort of contractual arrangement, would have to go to that particular theory in proximate cause.
Okay, but circling back, because one thing we do know, and there's actually no disagreement on this issue, that there will be a products liability jury instruction based upon inadequacy of warning.
Agreed. And that's the next one coming up.
Yeah, but my question is this, in a strict products liability setting based upon strict products liability theory, what's the causation instruction? Because remember, I mean, think about it from this, we go back to the roots of strict products liability 402A and so on and so on. The thrust and focus is not on the conduct of the parties. It's focusing on the product itself and whether it's a defective product and reasonably dangerous, right? And that's a different animal. Example, you don't even look at the conduct of the parties. We can all agree to that, right? So my question is this, when it comes to a strict products liability claim for relief, what's the appropriate causation instruction? It's really that simple.
First, Your Honor, I think when we're talking about strict products liability, we're talking about the public policy of maximum protection. If we're talking maximum protection, it's the broader, you gotta go with the substantial factor causation, which is, as you recognize, the virtually the norm in all the strict liability cases. And I know Your Honor prefers the 1986 edition of the jury instructions, rightly so, as they've been adopted by the Nevada Supreme Court, but the 2018 instruction doesn't even, under product liability elements, doesn't even say proximate cause. It says the defect was a legal cause of the damage or injury to the plaintiff. And it says... But
remember, that's kind of following what the Nevada Supreme Court was doing with 404A, because, and understand this, I haven't read the comments in years, but at one point I went back and tried to make a heads or tails as to the distinction. And it seemed to me, it's my recollection, and you can tell me if I'm wrong. For example, I'm almost positive Thomas versus Rexel Drugs and Company was a strict products liability case out of California, 1965. And then Carlson versus Jack, I haven't read that. But my impression was essentially this, I don't mind saying it. In all negligence-based cases, you give the normal, I shouldn't say normal, but typically you go with the approximate cause of injury, damage, loss, or harm as a cause which in its natural continuous sequence produces injury, damage, loss, or harm. This typical approximate cause. And then when it comes to legal cause, it was my impression that under those circumstances, if it's a strict liability case, that would be the standard causation given. And if I'm right, fine. If I'm wrong, fine. But I think that's really the issue.
Yes, Your Honor, I think you're right. I think that's exactly what you said is supported by the evolution from the 1986 jury instruction, at least in the 2018, because in the 1986 legal cause, they define it, and in the comment, they note, yes, this is the alternative, and there's only been one case that applied it, and it references the Carlson v. Jack case, which I do believe is a strict liability case. But in either way, 30 odd years later, when they do the 2018 pattern instructions, they just totally get rid of proximate cause on the strict liability instruction and have only legal cause, and then they have a greater history of case law.
I mean, I'm gonna be candid with you, I noticed that, but go ahead.
And I think to alleviate any doubt, there's one thing I know for certain from the Wyatt v. Rowett case, is that proximate causation is limited to situations where you have competing theories of causation and it can only be one. We simply do not have that here. We have multiple products that have concurrently contributed to an injury. At least that's the claim. And so for the jury to properly consider the facts and apply it to that claim, it has to be legal causation, because you're basically saying, that you can't prove causation under a proximate cause instruction.
Just looking here very quickly. And as far as the definition of interesting. And what's the definition of causation in the newer book, the 2000 and, what year was this, 16?
2018. It's the same, Your Honor, I believe.
What's the site though for it? Is that in products liability instruction section?
7.10 in the 2018 edition.
7.10.
It's the same as the 1986 4.04a. In the first part, it adds another sentence to it after that. It relates to a manufacturing defect, but that's not applicable here.
One of the reasons I asked that, I have the binder right down in front of me. And I just don't see that. Can you,
And that, is that the 2018 edition?
which book is this? I don't know.
I have the other ones too.
Because I don't know, 2000, when is this? The binder, what year is this? Anybody know?
The newer version, or?
What version is this?
I have no idea, Your Honor. I've seen it, I've used it, but the year it was published, I'd have to look through it.
Right.
Got a lot of notes.
Oh, I read them, Mr. Parker.
A lot of notes.
Well, believe it or not, this one was somewhat beneficial dealing with jury instructions for breach of contract, which are hard to find. But Mr. Pepperman, can you approach, and maybe you can find me, you guys can come up here, I just want to see it in here, and let me see that. But my question, once again, focuses on is a strict products liability case. And explain to me why substantial factor would not be.
Same copy I gave you.
Yeah, no worries.
Yeah, I cleared this with the conflict. That's our, we all have a couple different jury
Okay.
instructions. So number 3, the case all has like 7 pages. So, is there a copy?
So there's a version after that. You know, believe it or not, I think I did the, I don't know if they did it, but they did things like building instructions. I disagree with what they would say.
It's all over.
product liability elements definition still has the same approximate warranty there.
Okay.
And this one,
So that year would have been, hey, I didn't remember that sucker. I want to say this one is probably.
I still would like to get
the legal cause definition.
Yeah, they're still following 86. And let me see what you have. Can you make a copy of that for me? What you do have?
Sit down, bring my contract. I agree.
I don't think this is the early 2000s, so it's after 2000.
Yeah. I think that came out a short time after I became a judge. 2006. If then.
Yes, it's 2011.
There you go. That's
Probably
probably
right,
right.
2010, that's the
Yeah.
2011.
I agree. Interestingly, though, they were never adopted. These weren't officially, the 2018 wasn't officially, only 2000. Only in
1986 is shocking to me that we go through all that effort.
And I, yeah. So anything else I need to know, because I'm trying to, my question is this, and I understand, with it being strict products liability, under those circumstances with a different proof standard, why substantial factor wouldn't be the appropriate way to go?
Part of this, remember, is that it depends on the court rules with regard to their new cause of action for breach of implied warranty for a particular purpose, which also sounds like contract law.
Well, I think I addressed that. If you listen to what I said at the very beginning, and my question was this, when it comes to causation instructions as it relates to breach of warranty, for example, that might be a typical proximate cause instruction. In contrast versus strict products liability, substantial factor would be the test.
Well,
That's
Your
what I said at
Honor,
the very beginning, right?
but to be clear, breach of warranties are a strict liability-based causes of action, not negligence.
Well, I see it in the, even in here, it's in the products liability section.
That's correct. And if, in the 2018 version, the 1986 version doesn't have a claim for breach of implied warranty of fitness for a particular purpose, but in the 2018 version, there are elements, and it's legal cause, substantial factor causation. And we have a proposed causation instruction related to that claim based on the case law. It doesn't really say, the 1986 instructions don't cover it, so it is necessarily a special instruction.
Well,
But we'll get to that later. I just wanted to be clear that breach of warranty claims, any breach of warranty claims are strict liability based, not negligence.
I understand. You want to comment on that, Mr.?
I want to make an additional comment. Actually, go ahead, did you want to comment on that specifically?
I just, there may be a tort claim for breach of warranty. I think it might be under the restatement 402B. I don't know that the Nevada Supreme Court has recognized that. In the motion for summary judgment that we're still not clear on, what was cited was a UCC statute. That's a UCC claim. That's not a strict liability claim. UCC doesn't have anything to do with strict liability.
I just want to point out, Your Honor, so again, I've given Your Honor our citations and the fact that I think Mr. Pepperman kind of made my point for me at one point when I said there's really only one theory of causation here. Well, that's why you don't use the substantial factor. If you have two, if you have both fires coming towards the building, then the substantial factor is correct. When you don't have that is when you need the but for. And I would just ask Your Honor, if Your Honor is inclined to give a substantial factor causation instruction, that we define substantial factor. Because that's pretty vague for the jury to try to figure out on their own. And I have some suggestions on that.
Well, I'm pretty sure the Nevada Supreme Court has defined a substantial factor. I believe it's more than a de minimis.
We were looking at that in the case law came from the criminal context, and we didn't think it was appropriate to put it in our jury instructions.
We would refer Your Honor to Price v. Blaine, Kern, Arista, which is 111 Nevada, 515.
Judge, they jumped into the issue of foreseeable misuse. Price versus Blaine was the case out of Reno where they wore the character of the George Bush mask. And someone came behind the person wearing the mask, tipped him over, and the manufacturer said, oh, this was a criminal act that was unforeseeable. That was an unforeseeable misuse of the product. So that's what the case was about. That's where that instruction came from. This is not a misuse, number one. And number two, it's not unforeseeable. This is one of the purposes of the meter, to measure alkaline water. So to take something, to try to twist that Price versus Kern case, an unforeseeable misuse case, into an instruction here would not be appropriate.
Here, I mean, the way I do agree, you do have to have a definition of the legal cause definition, but they provided one. That's out of 404A.
Can we object to that? That's
No,
what-
no. I mean, I understand, I'm not saying you didn't object. I'm saying they gave a definition, a legal cause of injury, damage, loss, or harm.
I'm just not in here, you're saying.
Yeah. No, I have it right here. They give a definition. I agree, you have to have a definition of proximate cause. They have a definition of legal cause. This is taken straight out of the 1986 book.
Yeah, but it doesn't define, my issues, it doesn't define substantial factor. Well, that's my alternative issue. My primary issue is, I don't think that's the proper instruction, given the facts of this case.
Well, if he has a definition of substantial factor, let's hear it. This is the charging conference.
No, that's from Merriam-Webster.
You want it from the Webster, or you want it from? So I'll just give Your Honor two examples. From Merriam-Webster,
We're not gonna use that.
okay,
Fine.
then I would
No, we
propose,
can't use that.
I would propose the following.
I would tell you that if we use Merriam-Webster for a jury instruction, that might be problematic. I don't mind saying that.
Fine.
I'll keep it at that, right? That might be a problem.
Okay, then I would go back to Price versus Blaine Kern. It's not a substantial factor in bringing about plaintiff's injuries if those same injuries would have occurred even without the defect. That's what I would
That's not an unforeseeable misuse case. This is not an unforeseeable misuse. Take a look at that case. It's all about unforeseeable misuse. There's no possibility you can give an unforeseeable misuse instruction in this case.
Now, in looking at it, I'm going back to 4.04A, it gives a legal cause definition.
So is it an implied warranty, or is it?
Oh, we shouldn't have done that either.
I agree. That's what I'm saying.
No, I'm looking at this,
Take that one out.
You're correct, Your Honor. 4.04A gives legal cause. 4.04 gives proximate cause.
Right.
There's no definition of substantial factor that I'm aware of.
and so I don't want to open up Pandora's box. unless it's absolutely required.
Like I already said, we looked for a substantial factor definition. The only thing we found was a criminal case. We didn't think it was appropriate to take an instruction from a criminal case.
Anything else, any more record making you want to make on this issue?
Again, Your Honor, I'm gonna give you a price you're playing. Ms. Lowell informed me that that is a strict liability case.
I think you're saying it's
I didn't say it wasn't a strict liability case.
Okay, I misunderstood you.
No, it was a strict liability case, and the whole issue was unforeseeable misuse. That was the argument, that it was an unforeseeable misuse, and that is the context of the instruction, okay?
And that
This is not even a misuse, much less being unforeseeable. This is one of the intended purposes of the product.
I don't think it was about misuse. I think it was about a superseding cause. The guy was wearing a mask.
Yeah, but in the context of an
By
unforeseeable
someone
misuse.
else, and then he fell. It was about superseding cause with a strict liability claim against the guy who made the mask.
They were arguing that it was an unforeseeable misuse, and so that could be an intervening superseding cause, which is exactly why we don't have intervening superseding cause in this case, because not only is this not a misuse, it's foreseeable. This was one of the intended uses of the product to make alcohol, to measure negative or for alkaline water. So there's no way you get to any kind of intervening superseding cause here, because it's a foreseeable use, an intended use.
Anything else?
No, I think we made a record on it, Your Honor.
All right. And what I'm going to do is this, as far as the legal cause definition, and I'm looking at this more through the lens of this is a strict products liability case. It's not a negligence-based theory for liability. I'm going to give the legal cause definition.
And Your Honor,
Sir.
I'm sorry, did I catch you up?
No, I said sir.
Oh, and are you gonna leave it just as 4.04A, or are you gonna allow us to offer an instruction on the definition of substantial factor?
When they should have offered it already. They can't say we want to offer it later.
Well,
This is a charging conference.
we just did offer it. So
Well, what is it?
I just read it into the record.
That is not a substantial.
You can disagree with
Wait,
it,
wait,
but
wait,
I
wait,
just
wait.
read it into the record.
Read it one more time for me, just so I make sure I understand.
It's not a substantial factor in bringing about plaintiff's injuries if those same injuries would have occurred even without the defect, and that's from Price v. Blaine, 111 Nevada 515.
Okay, but here's my question. How does the evidence in this case even support that theory?
That a bottling water company was making hydrazine?
No, no, they weren't making hydrazine.
They
What they
were.
were doing is they were making alkaline water, and they were relying on your company's instrument to test the ORP readings in the water.
Right, and if you take an ORP reading and then you add product to it, should you be adding something that introduces hydrazine into your drinking product?
Well,
That's misuse.
that's, misuse would be standing on top of a ladder. That's not-
It's the use of the product. It's not the consequence of the use of the product. The use of the product was taking negative ORP readings. That is the use, okay? He can't say, oh, in this particular case, there was this contaminant as opposed to arsenic or some other contaminant. That's the whole problem, it's the
But-
use.
Mr. Kemp is good to make the record clear, but I understand that.
Yeah.
We're talking about the use. It's, for example, that's why I use the car battery example. If hypothetically it was being used to measure volt readings with a car battery, well, I think that would be misuse, right? Because it was never designed for that. And just interestingly enough,
No! Leave that alone.
who is that?
Mr. Rasmussen. Sorry.
No, you're fine, Will, I deserve it.
his dog was misbehaving in the video.
Who was it?
I'm glad to. And can we mute them?
Yes, we do.
Okay, I understand. Sounds like they have a dog issue. I love dogs, so. All right. I don't mind saying this, and that we made a record. I don't think the facts in this case support a product misuse case. You see a lot of those cases, and in the latter cases, I mean, it's pretty clear. They were using the product for the purposes of ORP readings as it pertains to alkaline water. And I think what their testimony is that 30% of these ORPs were being used for that purpose that they were selling. Dealing with the Kangen water and so on and so on.
30%, 1/3 was used for negative readings. He said in his emails that it was the go-to meter for Kangen water. He said it was fit for Kangen water in his emails. And he admitted, knowing that it was being used, he contradicted the request for admission action in April when they denied it. He admitted that he knew it was being used to measure negative ORP. So I don't know where you go from there.
Well, the problem is understanding alkaline water and what it is. This is not what this is part of the problem here. pH determines alkalinity, which is what Dr. Hutton said in his testimony right there in front of the court. One has to do with hydrogen, the other one has to do with oxidation.
I mean, can't we all say, and then we'll leave this alone, because I'm not gonna give a product misuse instruction. Because it wasn't being utilized to manufacture hydrazine. That wasn't the intent, right? It wasn't the intent to manufacture hydrazine. The intent was alkaline water. Hydrazine just happened to be a byproduct of the manufacturing process that they were utilizing, you know, and that's another issue for the jury to decide. But let's move on and try to use all the time we have and get through some of these.
Your Honor, are we going past 5 tonight? If we are, that's fine, I just need to make some arrangements.
I don't plan on it. I would like to get some more done.
Okay.
So now we're on page 21, right?
22.
Yeah, 22.
22.
Okay, this would be warning defect definition.
I think we agree on this one.
That's straight out of the book, right?
Right.
You can put a check mark by it. Okay, moving on, unreasonably dangerous definition.
Page 23, jury instruction 7.06, I think we agree on this one.
Do we agree? Defense? 7.06, page 23.
I believe it's in Hannah's proposed.
It is. We agree.
Scott?
No objection there.
I think one that we skipped of mine is this 406, it has to do with defendants, two different defendants, one is liable and the other one is decided that they're liable, the other one hasn't, sort of thing. It has to be changed up a lot. Or what happens when you find one of them to be, and the other one is not, and that's Nevada jury instruction from the 1986 version 4.06.
Are you talking about Hanna in Milwaukee, or are you talking about the media defendants vis-a-vis real water?
Yes.
Your Honor, that's a negligence instruction, and we would object to any negligence instructions.
So we just use 404A, which is in the negligence area.
Negligence claim against real water has been dismissed.
If you find that defendant, first actor was negligent, and that his negligence was a substantial factor, I mean, this is asking the jury to determine negligence, and that's not the claim.
Well, this is the closest thing I can find to figure out how to get to a spot where we have one party admitting liability based on 4 or 5 different causes of action, two of which were negligence per se, and the other one was negligence. Straight out, that's in the complaint. Maybe I didn't read the complaint correctly. Then you brought causative action against them for negligence.
You dropped them.
Okay? What do we do with regard to, we have one party that is saying, we are liable. Are they liable for everything, including the negligence causative action, or did you drop those and then they admitted liability as to strict product liability? Either way, something has to be done here that looks a lot like this in order to get to the jury. This is one group and this is another group.
I think the verdict form takes care of that, Mr. Rasmussen.
First of all, the stipulation, the real water sign said strict liability.
Yes,
We have not signed that yet.
We
well,
haven't seen it.
you don't have to sign it, you can either sign it or not, but we do need to get some progress here, and you held on to it for what, 2 weeks, week and a half?
I don't disagree with you on that, Joel, either. But we talked about
I
some
mean,
language.
we're instructing to prove, we're bringing these claims against Hanna and Milwaukee. These are the elements of the claims. This is what we have to prove. We're not saying you admit to liability. The jury is not instructed that you're liable because real water's liable. I mean, you just defend the claims that are asserted.
And yours, hold on one second. Your
I
verdict
will
form-
say this, I mean, I have ideas and it's on my job to share them with you.
That's true. Your verdict form puts us all together.
Right?
The verdict form says all the defendants.
Yeah, but
No,
here's
no,
my
that's not.
point. And I would,
Verdict form.
I even have
verdict form
cases
goes
I
back.
could cite for you, but I'm not gonna do that. Mr. Odou, I'm not gonna do that at all. Potentially on point, but I'm not gonna do it. But I'm not gonna give this instruction because this is not, when third parties intervening negligence is not a superseding cause. That's not this case. Right?
All right, well,
But what I want you to do, I want to be really fair. From an appellate perspective, a defendant, Hanna, right?
Right.
Has requested me to accept a intervening negligent superseding causation instruction based upon Nevada Pattern Jury Instruction 4.06. Is that
That's
correct? Yeah. And I don't think that's applicable under the facts of this case.
we'd also like you to look at Nevada Jury Instruction 4.09.
Okay, let's take a look at that.
Again, this is the definition of ordinary care. It's negligence concept. There's no negligence theory. We would object to introducing these theories.
The only instruction that would be even similar to something like this would be something like product misuse, and there's no evidence of that either, right? It's not, because these are tort-based, I'm sorry, these are negligence-based instructions, and this isn't a negligent case, right? The rest of the sole focus should be this. It really comes down to this. Is it a defective product under design, manufacturing, or failure to adequately warn and instruct? That's it. Conduct doesn't come into place, right?
Okay, understood.
But that's for the record, 4.09 is being requested, some form of that.
Yep.
So where do we go?
So the next one, 7.06.
I'm on page 24.
On page 24, we have a series of special instructions.
Did we get a ruling on 7.06?
Yeah,
Let me see what 7.06 says.
I think all parties agreed to 7.06.
I just didn't know if the court had ruled.
If you all agree, I'm not gonna rule.
We're fine with 7.06, 7.06, excuse me.
That's the unreasonably dangerous instruction.
Yes. Now, we also included as part of the strict product liability area, the misuse of a product means the following one to be instructed on 7.07.
Right.
And you just said that you don't think this is a misuse case. We do believe, and we believe that the evidence that we will put into the defense of this case will include issues regarding misuse.
All right.
back to 24 and try to get through some of ours? Page 24.
Wait, just 1 second. So I just want to make sure, you're offering up 7.07 as a misuse of the product
Yes.
instruction that should be given in this case, right?
Yes, Your Honor.
Real water, Judge Sullivan.
So does the plaintiff, Your
Yeah,
Honor.
we don't think there's any evidence of misuse.
Mr. Desitel even said that it would start to blink and go out because it kept getting wet and it's not waterproof, and so that's when it was starting to malfunction. That's a misuse by getting it all wet. You shouldn't do that.
Actually, it's being used for its intended purpose. If he was using it, and a really good example, to somehow charge a battery or something like that, it wasn't designed for that purpose, right? It was being utilized as an ORC meter, right? And for example, if there's an issue regarding it getting wet and someone suffered injury, maybe if it's measuring fluids, it should be water resistant.
Yeah.
And that would be a design defect, right?
Right.
I get it, you know? I don't see that though. It's not, because ultimately you would be talking about misuse by the end user, the consumer, right? Standing on top of a ladder. You don't do that. There's warnings. And this is important too. When it comes to product misuse, you usually have warnings. And the focus comes in that they warn against the misuse.
So the misuse here, just remember, our warning side of the box even says don't use in certain temperatures. They did, and that will be part of the test.
Where's the evidence of that? They used it in a facility for Desert Inn.
We'll have Dr. Babcock will talk about his use because he did get all the photographs, he did review all the stuff with regard to the Henderson facility. He actually went to the Henderson facility and investigated with regard to whether or not the temperatures that were there were within the warnings there.
That's not in the non-opinion.
That's not in there.
It's not in the non-opinion we had before.
Your thoughts on that, but I think it is there.
Okay, we'll deal with that, but it doesn't, that's an evidentiary issue. But at the end of the day, really focusing on product misuse, this is not a product misuse case.
Thank you.
Judge 24 on ours is just the Stackowitz instruction. I don't know if that would objection or not.
I don't agree with this one because of the word specific defect. This is a warnings case. I'm not sure product liability against us. If this is meant for Joel's side of the thing, then I kind of get that. But if that's what it is, it shouldn't say plaintiffs need to prove and this is why when we put in here the failure to warn stuff, that's what I thought this was going to go to. This is not a case with regard to a specific defect. It's a specific problem with the warnings under strict product liability. And so it needs to say something about the warnings as opposed to this nebulous or these vague terms of specific defect.
We will say specific warning defect.
Yeah, that's.
Your Honor, I just, for Milwaukee, I don't think the Stackowitz is an appropriate instruction for this case, period.
Yeah, that case had to do with the steering mechanism in
And it
the
was
car.
a sudden, and it was unexpected and dangerous malfunction. So when you have that situation, and you don't have, that got into the component part and all that stuff, but we don't have that in this case. This is a failure to warn. This is an inappropriate instruction.
The Squirrel case specifically held that you should give a Stackowitz instruction in a breach of implied warranty case. That's a specific holding of the Vascular Court.
Nissan Motor Company, again, I'll just say it had to do with the steering mechanism of the car. This is a failure to warn about how long it takes to oxidize a probe. I think that's what you're trying to prove. And so this particular case, it should not be here with regard to language that talks about a specific defect. There's no specific defect in there's no design, there's no manufacturing defects. That's not, and that particular case had everything to do with a specific defect in the steering mechanism of a Nissan motor vehicle.
And what's the case? I just want to make sure.
It is Nevada Contract Services, Inc. versus Squirrel Companies. It's a Nevada Supreme Court case, 2003. and they held a degree of specificity to sustain the causation burden when claiming a breach of express or implied warranty. That was the issue on appeal, and the degree of specificity. And so they held that you should use Stackowitz. Okay. Although, and this is what they say, although Stackowitz is a product liability case, we are adopting a similar causation burden in breach of warranty actions. And it discusses Stackowitz. And then applying this reason, we conclude that it is too burdensome to require plaintiff to prove precisely why a product does not work in a breach of warranty action, specifically in instances such as the one presented here, where a product integrating electronic and mechanical components is involved. So we have taken the squirrel case, and we have an instruction based on the squirrel case. If you find that the MW500 ore meter was not fit for the particular purpose of taking negative ore readings or making alkaline water, defendants cannot be held liable unless we prove by preponderance of evidence that this was a substantial factor in causing the industry. And then when in making this determination, you should consider all the evidence to determine whether it supports a reasonable inference that the meter was the source of the trouble and the cause. And I think we didn't even go as far as the squirrel case went to that instruction, but that's what we relied on, Your Honor.
The citation,
The citation for the
24
squirrel
is the
case
second
is-
case.
is 119 Nevada, 157.
It's kind of jumping ahead, Your Honor, because it's on, the squirrel case is referenced on page 32, and we're on stone page 24, so that's
Right.
How many more do we have?
a lot.
Too many.
30.
We're on page 24, we go to page 54. The last several are just standard closing instructions, and then some of them are instructions that are just slightly modified that I don't think we'll have too much of a dispute on. But the next 10 or so are going to be.
My staff has other things they have to address, so we have to leave now. But here's my question, where do we find time to finish up on these jury instructions?
You know, I'd point out, we're way ahead of the game on this thing, so even if it was Thursday or Friday,
No.
we could still argue this, so.
Judge, I don't know.
We're way ahead of the game, Your Honor.
You said that.
Just because we were efficient. I mean, Judge, I don't know what's your schedule tomorrow. But we can come out.
All
Yeah,
right.
the jury's coming at 10:30, as I understand.
Well, I have a long motion in the morning.
We can come at 10 and knock out another half an hour if you have a half an hour.
I don't think I do I?
Well, we can submit them, Your Honor, and the court can make a decision.
What time will we finish tomorrow as far as testimony is concerned? What do you
At
think?
5 o'clock, close to it, I'm guessing.
And the next day? When will the defense cases be completed?
Wednesday or Thursday.
Pardon?
Wednesday or Thursday.
Judge, they don't have enough to go on Wednesday or Thursday.
Wednesday or Thursday this week, you mean? Tomorrow's
I
Tuesday.
think they're going to be struggling to finish, or to keep it going on Wednesday myself.
That's what I just said, Wednesday or Thursday, so.
Okay, all right. Well, what we're gonna have to do is this. You think you have enough? We have to finalize these instructions either Wednesday afternoon or Thursday. Right?
Your Honor, if I could suggest that I can meet and confer with defense counsel on the rest of these and try to narrow it down to the few that we have significant disputes over. And if we have the time, we can try to schedule time to work through those remaining ones and then otherwise submit it to the court. But I think we can get it down to the last, 8 to 10 where there's actual disputes.
Yeah, the verdict form will be in dispute as well. I think the ruling that you need to do on 706 have to do with this new cause of action, something we probably need to have guidance on.
And
Like a summary judgment ruling,
for the record, I don't mind telling you this, and then we'll go. And I haven't had a chance, I mean, I didn't really come prepared to discuss the impact of that motion for summary judgment or whatever it was. And I've written down, that would be, let me see,
Number 6.
number 6. I've written down, is it 306? But I have it down here, right? Yes, I have, yes, docket 307. I have the language from the, and also a copy of the transcript Mr. Robbins gave me. And I'll go back and I'll make a determination as to what to do with that last issue as it pertains to the breach of the warranty instruction.
And Your Honor, lastly, this person who said was not here, she's still not here. She was supposed to be here. Mr. Rasmussen, you'd be disappointed if she wasn't here. I'm disappointed.
Tuesday,
We were
we
gonna
said,
work it.
Tuesday is the trial, this is all about jurisdiction. I don't know if she's gonna come to this jury hearing or not.
The other two did, the other two were right there.
Well, good for them. I'm glad that they're doing that, but I don't know.
Your Honor, just for the record, Mr. Jones, Wayne Jones has, to be back in New York. So we want to get him on and off tomorrow.
I'm fine with that, Your Honor. I'm not asking we delay Mr. Jones.
I appreciate that. I just figure the issue with the observer may take longer than we anticipate, because we don't know what the issue fully is yet.
we'll do that lunch.
Hopefully it's a small issue, but it may not be, I don't
It
know.
may not be. I'm fine with getting Mr. Jones off.
Thank you.
I don't want,
I don't want the jury to be sitting around waiting for us. So, yeah, here we go.
Off record, Judge?
And thank you, ma'am, for coming down and helping
You're
us.
welcome, Judge.